Many expats living in Vietnam focus on visas, employment contracts, and investment structures. Estate planning is often postponed. Yet relocation creates additional legal layers, not fewer. When death occurs, multiple jurisdictions may assert authority simultaneously. An expat in Vietnam may hold assets locally and abroad, real estate in Ho Chi Minh City, bank accounts overseas, shares in foreign and Vietnamese companies. Each asset category may be governed by a different legal system. Effective estate planning for expats begins with identifying where assets are located and which legal systems may apply. Vietnamese law governs immovable property located in Vietnam. For overseas assets, applicable law depends on the law of the asset's location and relevant conflict of law principles. Nationality alone does not determine succession outcomes. Vietnamese law recognizes the right to make a will. However, it also includes compulsory heir protections for certain family members. Expats who assume full testamentary freedom may encounter statutory limits for Vietnamese assets. If you are married, marital property classification determines what forms part of the estate. Assets acquired during marriage may be considered common property under Vietnamese law. Only the deceased share is distributed through inheritance. In many cases, maintaining a separate Vietnamese will for assets located in Vietnam improves clarity. It reduces reliance on foreign probate recognition. However, coordination with existing global wills is essential to avoid conflict. A will drafted abroad may be used in Vietnam, but legalization or consular authentication and certified translation are typically required. Procedural defects delay estate administration. Planning should anticipate documentation requirements. Foreigners may own certain categories of commercial housing in Vietnam, subject to statutory conditions and ownership limits. Land itself remains owned by the state, with individuals holding land use rights. Upon death, heirs must comply with both inheritance law and housing eligibility regulations. Legal entitlement does not automatically guarantee indefinite retention. Expats who hold shares in Vietnamese companies must coordinate estate planning with corporate governance documents. Shareholder agreements and buy-sell clauses should align with succession strategy. Control should not transfer by accident. Vietnam does not impose a traditional estate tax. However, inheritance may be subject to personal income tax unless exemptions apply for close family relationships under Vietnamese tax law. At the same time, the expat's home jurisdiction may impose a state or inheritance tax based on domicile or residency. Cross-border exposure must be reviewed holistically. Tax residency status affects cross-border inheritance exposure. Expats should periodically review whether their presence in Vietnam changes domicile assumptions abroad. Residency impacts estate taxation in some jurisdictions. Many expats have spouses or children with different nationalities. Inheritance rights may differ across jurisdictions. Clear alignment of marital property and succession planning reduces dispute risk. Under Vietnamese Civil Code, minor children and adult children without working capacity qualify as compulsory heirs. If such heirs exist, exclusion through a foreign will may not be fully enforceable in relation to Vietnamese assets. Statutory minimum shares limit testamentary discretion. While powers of attorney can assist during incapacity, they terminate upon death. They are not substitutes for estate planning. Formal testamentary documents remain essential. Without coordinated planning, probate may occur in Vietnam and abroad simultaneously. Recognition of foreign probate decisions requires separate procedure. Delay and cost increase when structure is fragmented. Heirs often struggle to locate original wills, property certificates, or share certificates. Maintaining accessible documentation reduces post-death complexity. Administrative discipline supports legal clarity. In some cases, lifetime asset restructuring may simplify estate administration. However, such actions must comply with Vietnamese civil and tax law. Improper transfers create future disputes. Expats should review estate plans whenever significant life events occur. Marriage, divorce, birth of children, asset acquisition, or relocation all affect inheritance structure. Static plans do not fit dynamic lives. If you live in Vietnam and hold assets across jurisdictions, estate planning should be deliberate and coordinated. Vietnamese inheritance law may apply to local assets regardless of nationality. Global alignment prevents conflict. For expats living in Vietnam, estate planning is not merely administrative. It is a strategic decision affecting family security, business continuity, and asset preservation. Cross-border exposure requires structured coordination. Without proactive planning, default legal rules will determine the outcome. If you are living in Vietnam while holding assets across jurisdictions, estate planning should not be an afterthought. Vietnamese inheritance law may govern your local assets regardless of nationality, while foreign tax and succession rules may still apply abroad. To align your marital property regime, wills, corporate interests, and cross-border tax exposure, contact LTS Law at lts.com.vn for structured estate planning guidance. For expats, stability is not created by relocation, it is created by deliberate legal design.